You start, okay, so we'll go ahead and commence the show. Hi, you are listening to Mediation Station, and this is your host, Greg Fenton. Each week we explore topics related to the experience of people with conflict and look to promote the profession of conflict resolvers. We are available to connect with at Fenton Mediation, FentenMediation at gmail.com and at 647-227-4734. Visit us at our Facebook page to like us and Facebook group page to become a member. Also visit YouTube channel Fenton Mediation to see videos of past shows, including this one, which will be soon enough. You can also listen to podcasts of Mediation Station on SoundCloud, Apple Podcasts, and Google Podcasts. Please follow us at our Twitter account at Fenton Mediation. So, some information. Our topic for conversation today is called Family Mediation. What's law got to do with it? With Neeraj Goel joining for conversation, and that Laura Tarcia is with me to co-host tonight. We're continuing the program live each Sunday night from 8 to 9 p.m. through Zoom due to the radio station CHHA 1610 AM needing to adhere to COVID-19 measures that restricts any live in-person programming. We will engage in conversation with everyone attending able to listen and watch the conversation. Microphones and webcams will be closed. And if anyone wants to contribute anything, there are two options. One is to see the chat icon as a bubble at the bottom center of your screen for you to click to then type in a comment or question and click to send. Or you can click on the reactions icon that is also on the bottom center of your screen for us to see. Click on the hand icon and then we'll open up your mic for you to speak and you share your comment, and then we'll close your mic. The show is being recorded for both video and audio purposes. That will be uploaded for public access on SoundCloud, Apple Podcasts, and Google Podcasts, for example, once I get around to it. That is the audio version for sure. Laura and Anthony, who I want to acknowledge for each week, are responsible and have taken that responsibility themselves to edit for video purposes. Today we're talking about family mediation. What's law got to do with it? And Laura's here with me. So Laura, you're usually here with me once a month, and tonight's your night. How you doing? How you doing?
I'm doing really well, thank you. Tonight is my night because it's my favorite topic. So I'm hoping I'm giving enough space for our guest.
Well, I don't know if we'll let him speak anyways, but nevertheless. So we want to open this up by sharing that with us is Neeraj Goel.
Yes, hello. Well, and a little nod to Miss Turner.
So what did you hear there, Neeraj?
Oh, I heard What's Love Got to Do with It?
Yeah.
Yeah, and it's just, you know, I'm of course a big Tina Turner fan, and so I think it was a great topic, choice of title for tonight.
We just wanted to give you that also, that, you know, that sense of connection with the play on words. What's love got to do with it? What's law got to do with it?
That's right. That's right.
So thanks for being here with us tonight.
Thank you, Greg and Laura. I'm really honored to be here tonight. Thank you.
You might change your mind by the end of the program.
I don't think so. I have seen both of your programs and I've enjoyed them both.
And when you say both, you're referring to Laura. Laura used to have a program too.
That's right. Yes.
Did you want to do a shout out? Come on.
Back in the day, we used to, yes, we used to. Life got busy. I really, really enjoyed that program as well, but life got really busy. I think it's such an important program to educate the public about everything that has to do with conflict resolution. So maybe one day we'll revamp that somehow.
Yeah, so tonight's program is going to focus on family mediation. With Neeraj, for yourself, what is the difference for you, or what is different for you over these past number of months? This
You mean
past year? Yeah,
with the
the
pandemic?
past year. Yeah, that's right.
It's been a time of reflection for, I think, for all of us. And I have had moments of sadness like everybody else. And it has been difficult for sure. I've also felt very grateful because my life is, has maintained a level of stability. And it's very sad to see, when you see the TV or read the newspaper about what some people are going through. So it's just a very difficult time for sure. But I feel grateful.
So why don't you share some information about your professional journey, just to give some, people now and in the future some clarity as to who is Neeraj and where does he come from?
Oh my goodness. Well, so I'll speak pretty much about my professional life. Yeah.
Yes. Yeah.
Okay.
For sure.
Well, I was called to the Bar of Ontario in 2000, and for my first 5 years of practice, I was a young lawyer taking whatever job I could get. And in 5 years, I had 5 different contracts. Every year, I was taking over for somebody on mat leave. And I was a clinic lawyer, a legal clinic lawyer. I was a policy lawyer in the Ministry of the Attorney General office. I was a litigation associate. And I just moved around really with not a lot of focus. Around 2005, I decided I really need to get serious about my career. And I thought, I want to become a family lawyer who specializes in alternative dispute resolution. So to specifically do collaborative family law and family mediation. And I got in touch with a lawyer who did exactly that. Her name was Marion Korn. And she happened to have an office, a spare office in her office. And she said, why don't you hang up your shingle and you can watch me work and you can take a chance and, develop your own practice. And I decided to do that. And 16 years later, I'm still a sole practitioner who is focused primarily on family law and family mediation. And at that point, I just learned family law, and proceeded on my journey.
When I use the word influences, who have been influences in your life?
Well, I think it would only be fair, because it's not just because my parents are listening, or will eventually see this, but I should give them a shout out. So obviously my parents have been a big influence, especially by giving me an opportunity to be educated and for making it possible for me to go to law school and for supporting me in my career all these years. So definitely them. And I think I've been influenced by Marion Korn, who I mentioned a minute ago, and by a lot of the more senior lawyers and senior mediators who I've encountered, in all these years.
Do you like it?
Do I like doing what I'm doing? Sure, absolutely. It has given me a way to earn a living and to have a nice life and to help people in an area of the law that is the closest to what I could possibly do. When I started articling, As an articling student, I was articling in a litigation firm, a commercial litigation firm, and I was doing commercial litigation stuff, and I could not relate to Coke suing Pepsi, right? For example, I could relate to this person having a conflict with this person. So I've always gravitated towards social law, and family law was the one area where, you know, I could do that well. You know, other areas are social assistance law, landlord and tenant law, disability law, the stuff that you learn, the stuff that you do when you work at a legal clinic. But family law was an area that I could relate to because I relate best to people, not companies. You know, not the complex things. I relate to people on a micro level.
Mm-hmm. And people are sometimes, most of the time, more complex, and they have much more complex issues and factors driving than Pepsi suing Coca-Cola.
Yeah, absolutely.
So
Absolutely. And I'm sure you all feel the same way. You do you know, because we're all in the same field. I think we're all people who are interested in the micro level of people as opposed to companies, those kinds of things.
Yeah, I mean, dealing with people, we, you know, identify them as human beings, and they're not objects per se, and they're not entities. They're like a business would be. And there's affect and there's effect on people in terms of people and humanity, their lived experiences. There's, you know, the trauma that people go through, the crisis, especially in relation to family matters.
Yes, absolutely. Absolutely.
So why did you put your focus then basically as family law? What was the precipitous event?
To be honest, it was because I wanted to do family mediation, I want to do mediation, and doing in the family law context, there is a great scope to do mediation. So I very, very early on knew that I wanted to do mediation, and family in the family context was an easy way to do it, right? You can do mediation in the labor context, you can do it in civil litigation context, but I think the family context is something that I just naturally gravitated to. I thought it was the simplest for me to understand.
Because it was more aligned with who you already identified yourself as.
Yeah, I guess so. Yeah, absolutely. Yeah.
sorry, I had a chat that I had to ask. I need to close quickly. Okay, sorry.
Are you multitasking, Ms.
I'm not
Flora?
multitasking. There are, believe it or not, people on a different platform who are asking how they can get to in here on a link. So just a little bit of multitasking, but still tasking on the same. The focus is still here.
Well, get the party started.
The focus is still here. I mean, I find it very difficult to even, sometimes it's rare to hear that as a young professional you gravitated towards family law, where truthfully probably every single family lawyer whom I heard from said that there's no way family law was the last thing they would go into because it's so complex, it's so difficult, it deals with so much emotion, it deals with so much you know, trauma, what Greg is saying as well. So all of those factors, they impact you. You take them with you, and they form part of your lived experience day after day, and your fabric changes and shifts with every single story. So I find it very I actually, it's rare to hear, so I was surprised to hear that from you, that you gravitated initially and originally towards that anyway.
Oh, I don't know, Laura. I feel that there are so many young law students who say, I just want to do family law.
Oh.
So I hear that. I certainly hear that. I think what is kind of unique about my journey was that I was never a family lawyer who did much court work. I was a person who went into family law and said, I'm not gonna do litigation at all. So I have tiny experience being in court, and I have a lot of experience doing out-of-court settlement. That's kind of unique about my story, because all of my colleagues, my older colleagues, and probably some of my younger colleagues, were all lawyers who were in court for a period of time, and they said, I don't want to do court work anymore. And then they went and did collaborative family law and family mediation.
Right, right. And unfortunately, we hear that story quite often too. So we do work with most of the lawyers whom we work with are collaborative lawyers, or not necessarily trained in collaborative law model practice, but they are collaborative in nature, the way that they approach and they tackle a particular issue between families or within the family. And we do hear that a lot, that was it was because they were exhausted, they were sad, they were frustrated, they were drained emotionally, everything. So it wasn't worth it in the end, the battle, the fight, the ongoing, aggressive posturing and back and forth, which unfortunately the system sort of sets you up for in the beginning.
Well, it's interesting, Laura, that when I first started, a lot of family lawyers would say to me, if you don't do court, you'll never be a good family lawyer. And that's not true. That's not been my experience. I'm a settlement specialist. That's what I do. I may not know the court rules very well, but I certainly know how to get a case done.
Okay. That's good to know.
Yeah.
So would that say that, especially to you when you were going through those conversations from people, that there was resistance to the kind of a approach that you were trying to promote within family law?
It wasn't, well, certainly it did start with me. There was already a collaborative family law movement that I joined, and a family mediation movement that I joined at that time. But it's just that people kind of saw me as the new kid on the block, and they really said, Neeraj, you really should be getting some court experience. And, I was just not interested in doing that. And I don't think that it has adversely affected my ability to do a good job for clients. I think in some ways, I was never that jaded, exhausted litigator who still brought the mindset of litigation to my settlement negotiations, because I didn't know that litigation mindset. I still don't know the litigation mindset. And sometimes I come across that litigation mindset with another lawyer.
Right, though you still know that's reality.
Sure.
The shadow of the law that does impact, especially within negotiations that you're trying to help support.
Absolutely, and I know we're going to be talking a lot about that in this session. So absolutely, yes, and I believe very much in it too. So yes, it's just the litigation aggressive sort of style. I never had to do it, and I have never subscribed to it in order to do the work I do.
Yeah, and I would say for me, I'm not a lawyer. I don't have a legal background. I have legal experience in the sense of being present in different settings of court and engaging in the process and understanding that conceptually. I would say it's traditionally, collaboration is not necessarily something that's conducive to when you hear the word law or justice per se. It's really the word adversarial, positional, fighting with each other. And it might have been from some of those people that were pushing their agenda because that's all they knew. And so you're somebody that was outside of that box and somewhat of a threat to the traditional notion. And, people struggle with change all the time, especially lawyers, from my experience.
Absolutely. But again, to be fair, the collaborative family law movement was very much, there in 2005 when I first started. And in fact, it started in 1992 with Stu Webb, who was a family lawyer out in Minneapolis. So it's been there. It's matured quite a bit. Absolutely.
It's been there. It's funny because I was just reading a little bit of an article about that movement that started sometimes in 1970s or so. And there were a couple of schools of thought in terms of why did we need a movement in order to make the law, the practice of law collaborative, and why was it not that to begin with, or the approach, the foundation, not that to begin with, a collaborative approach, and we needed a movement to sort of show that or train others or lawyers for collaborative. And that's one school of thought. Why wasn't it there again? And the other one was, it will never work. It will never work out because of the model itself may be limited to a very small group of people,
Yes.
families who can afford, and affordability factor is a very important factor when engaging a collaborative lawyer, because or entering a collaborative process, because I don't have to tell you, but there are other professionals that would come into play. There's the neutral professionals. Some can engage, whatever, experts for financials, parenting, family, whatever the case may be, on a particular, and that can get quite expensive for people. And the other reason why it was postulated that I may not be a good idea is because of the agreement that one enters into. So the client, the parent, enters into an agreement with a lawyer, whereby if collaboration fails, then they have to start all over with a new lawyer. So they would have to dispose of that, to get a new lawyer, start the whole story again. I love the model. I think the multidisciplinary team and teamship and approach is absolutely brilliant. That's what it should be applied to every single family, because it meets all of those needs and diverse needs of each family. But
Yes.
not many family can afford it.
Yes, and so let me just say that I love the model too, but I'm no longer doing any collaborative cases. My practice shifted about 3 or 4 years ago to just really focusing on family mediation and being an ILA lawyer for clients who are in mediation with other mediators. And I moved away from collaborative. And look, I love my colleagues who are doing collaborative, and sometimes I miss it. But overall, I just felt that mediation was a better fit for me. You talked about two things. You talked about the cost, and you talked about, what was the other thing that you spoke of just now?
The cost, and then if he fails, then they would have to retain a new lawyer and start all over again.
Yeah, but Laura, to be honest, I have never felt the cost to be any more than what clients are going to pay if they go and see traditional lawyers. So when I was doing collaborative, I didn't feel that way. And then in terms of that agreement, that if the parties reach impasse and they're not able to reach a deal, then they have to let go of their lawyers. That was an incentive for people to remain in the collaborative process. To be honest, the truth is, for me, that I again love the work that collaborative lawyers are doing, but just for my own personality, I have just felt that being a mediator and working directly with clients is what I do best. That's all it is. But I take no fault with with collaborative practice. I think it's a great process. And I think that where there are some cases, here's what I would say. Whenever I have clients who call me and say, look, I'm separating from a spouse, and what process should I choose? I will say to them, look, here are the different process options. You can do mediation, you can do collaborative, you can do traditional negotiation, you can go to court. And what I say in terms of mediation is that it is for those clients who have the highest level of trust and the lowest level of conflict. Then, so I say between, one and, if out of 10, we would say level of trust is 7 to 10, that level of trust. Then if you're lower than 7, then try collaborative practice. And, let's say between 4 and 6. And then if you're very, very adversarial with each other, then maybe you need to go and see a traditional lawyer or to go to court. I do not fault any clients who choose any of the process options. We need all of them.
Yeah, that's what Laura and I and others and you, what I'm hearing is that we promote about options. It gives opportunities. Life and society, community is made up of diverse perspectives. And so the more options we can provide that will connect with the diversity reality that's out there, that's the power for people to get access. I know the terminology people call access to justice. I use access to options, where it's more community-based rather than let's go into the system as the de facto or the default and let the system help support us with our decision-making. Actually, it's to promote, let's keep it in the family or the relationship out in the community and minimize the need to go into the system, though recognizing there are circumstances and situations that need to gravitate into the system. And so options is the power.
Absolutely. Absolutely.
Making,
go ahead, Laura.
No, go ahead.
No, I was just going to say that, look, I don't fault any of my family lawyer colleagues who are sharks, barracudas. They are doing the Lord's work. We need them, and we need our lawyers who are dolphins, such as myself, right? It just depends. It just depends on what a case needs. Yes. Earlier on, I was very cavalier in my career, and I was thinking, I'd get these, I was like, oh, these clients who are going to court, if they only talk to me, I could, solve their cases out of court. No, not necessarily. Some people need to go to court. I understand that.
I think as long as the information is delivered in a sensitive way and meet people where they're at in terms of in terms of culture, language, understanding, sophistication in terms of a particular aspect of their lives. That information, I have found that we are not doing a really good job at delivering in terms of, meeting people and going at, ground level to deliver this information in communities where we allow them to make an informed decision about these options. Because we do also inform about options. And I started a nonprofit a long time ago, and we still carry on with the family law information sessions in the community, which is essentially almost the same information that you would get in the mandatory information program when you attend court or prior to engaging in the system and being stuck in there really majority of times. But we are delivering that information in communities and in libraries in various regions, from Durham region to Toronto, York, whatever the case may be. And we have found the way that it needs to be delivered is so different from Durham region to Toronto to Peel to wherever we go. And now we're doing it online. The questions are so different. The needs are so different. The communities themselves require something different. So I'll give you a very good example. In Durham region, we have a growing Muslim population. They deal with the law, with the Ontario law, in a very different way than, you know, we would have, you know, the Romanian community that deals with the law in Ontario. They required very different deliverance. So we've had the fact that we were able to deliver this information in libraries, for example, where we thought it would be the safest place for someone who may not be able to leave the home or attend, you know, or pick up a call and ask, you know, a lawyer or a mediator, what's my next path? They would go to the library. So they would come to the library to ask these questions during our family law info sessions. And they would come sometimes with their sister, their brother, with, you know, a support person. We actually, in fact, had families who came together as a couple. And everybody got the information where they felt safe to receive that information and also to ask questions. And I can tell you that it is very, very, very different than anything you would be, you know, ever hearing on the phone or, you know, even through these programs, because it's real, it's raw, and you can never see it unless you do it then and there on the ground level. So I have a little bit of an issue. I'm okay with, obviously, we are promoting options and access to options, and families do need to have access to options, but do we deliver it in a way that they hear it the way that they need to be hearing it?
Absolutely.
That's kind of how my fear has always been, that because we need the right information for the right people, for the right group, with a particular understanding. So that's my passion. So that's my side passion behind. You can sense it probably because my cheeks are gonna get red, but that's what we do in community.
To give information on options.
Yes.
that is your work. Absolutely.
I think it's a critical word, because you know what, even when you were speaking, that yes, there is a system that there are families who do need to go to court. There are families who do need to get to collaborative or mediation arbitration, whatever the process may be, and, you know, describe it in detail, all that stuff. However, we've also encountered families who really thought that they are at, you know, 7 level of trust, and then when they go into the mediation or in court or in a particular other option, they realize that their trust is at 2, and vice versa. We've had families who said, no way, she's not going to disclose financial, he's not going to take the kids at the particular time, absolutely no trust whatsoever. And then they sat at the table and they discovered that they are much more aligned, and there is a trust there, but it is because they heard it from a different lens. We worked together to create a different foundation, or recreate and shift. So that's what I saw. I see the power of mediation, because it doesn't have that incentive, right? Like mediation, arbitration will have that arbitration incentive. Collaborative law will have the incentive of like, well, you're going to have to pick a new lawyer if this doesn't work. So I don't know if it's, I would be reluctant to call it incentive, because it's a little bit of a threat, that, or a hammer above the head type of thing, for lack of better words, saying that if you're not going to settle here, this is what's going to happen. You know, a stranger or someone else or something else is going to happen to you and at you. So I love the idea of mediation, because that doesn't happen. I mean, it may happen depending on the mediator, how they conduct their mediation in whatever manner, but it doesn't happen in terms of a fear that if I don't agree to this, then I'm going to get punished in a different forum or in a different format. Right? So, sorry.
Yes.
I know
yes,
my
I'm
shifting the incentives a little bit here. I'm making Greg rebrush his hair.
Whatever's remaining.
I'm not too far behind you, Greg.
Well, it's a passion for Laura. If I can speak for that, you know, it's a passion for me.
Mm.
We're similar in terms of what we see this, and with my background in community mediation, that's the foundation where the ownership of the process in terms of creating the conditions are adapted for the people involved. So up in Jane and Finch, where I was part of, doing the delivery of the service, that it was an intention of the program for diversity inclusivity. We have over 40 different languages that were represented on the pool of mediators that were able to give the process an opportunity. So it's not to say people had to fit into the box. It's the box transformed and shaped for the people.
Absolutely. Absolutely. No, I have a lot of respect for you know, what you both do as community mediators. You know, a long time back, I was a community mediator at St. Stephen's. I'm sure you both have heard of St. Stephen's Community House. Did a lot of neighbor disputes at that time.
Were you on their roster?
I was on their roster.
Can I ask when? What's the time frame?
Oh, I'm going to say it was 95 to about 2000 or so.
Wasn't it a little later? Because I was up at Jane and Finch area.
Yeah.
And I believe I recall your name
Do you?
as part of the dynamic there. Because I started at CMSD Downsview in '98.
I wasn't a very prominent member. You know, I was just, you know, a little volunteer.
Everybody was a part.
Just a little tiny little person there, you know, take a couple of cases. I really, and that transformative style is one that I use a little bit in the mediation that, you know, still I take a little piece of that sometimes, some of the techniques that they taught us there. And I use that sometimes in my mediations.
Yeah, so transformative is identified with Bush and Folger. That's the promise of mediation. I transition myself with that, and I refer to transformational. It's a more fluid, active, adaptable process that's not necessarily defined by this is the particular way we do things, because the actual model is we do it whatever way is needed.
Yes.
It shifts and transforms depending on the people.
Mm.
Greg just wants to be difficult and make things very difficult, obviously.
Yeah, I'm all about social change.
I do only family mediation, so I don't do community at all. But the community side of it, I think it is very important to connect with people and to connect with the shifts in families and shifts in family units and where they're at now, as opposed to 10 years ago. Families have very different questions today, and families need very different things from a separation and divorce. Including, you know, anywhere from the speed of the process, the cost efficiency, to the fairness, to the sense of fairness. What I was trying to say earlier is that I think if we present these options in a community to in a way that gets delivered appropriately to that community and those needs and the factors, then I think we are doing a service to the field as a whole, to the family mediation field as a whole, and remind families that they are the experts of their family. They are the ones who ultimately and primarily should actually make the decisions when it comes to their children, their financial division, whatever the case may be, their future unit, the reorganization of their families. So it serves as a reminder, no matter where, that should be the default. And I believe strongly that should be the default, because unfortunately, the reality is that families have not been through a separation or a divorce. Most of them aren't. It's their first time. So they don't even know how they will act or react or respond to the transitionary elements that we're working with, right? So with the financial division, with the question of, when are you going to see little Johnny, what are you going to do, for holidays, all of that stuff. They don't know yet the answer to that question, and they don't know how they will behave or act to it. So I think it's fair to the families to allow for that space, for that to happen in the least confrontational way, with the least amount of fear and threat, and still with a lot of structure, because there is a lot of structure, as you obviously, you have in a mediation. But families don't feel that there's a lot of structure. So we've heard lots of, I hear this question all the time that, well, I don't want to come to the table because he may not disclose whatever, or she may not disclose her RSPs. And I say to them all the time, well, then we're not going to proceed with mediation. It's a request, it's a requirement, they'll have to do it. And if they don't want to do it this way, they may unfortunately end up in a much, in a less positive. So then that's the incentive that we say, well, you have to do it. So it's not that.
And that is kind of the hammer that you were talking about a few minutes ago. Yes, there is. And, there is obviously that hammer there for sure.
There is.
It's a voluntary process. However, if you don't reach a deal here, then there are consequences.
So understanding, how do you ensure that people are aware or informed of their legal rights, especially when mediation is an interest-based process, rather than a rights-based process like court?
Okay, yeah, really, really good question, Greg. The way I run my mediations is that it is very legal education heavy. Okay, and it's perhaps a little legal education heavier than I'm sure what some of my other colleagues do, perhaps even what Laura does. And it is that I want them to understand their legal rights and their responsibilities, because we are living in a rights-based society, even though mediation is not. But and this is what the title of this particular session is, what's law got to do with it? Because it is about being in the shadow of the law, that it is still the default. I'm not making a value judgment whether that should be or should not be the case, but ultimately these are legal contracts. And so I am very big on education around the legal model when it comes to the financial issues, property division, child support, spousal support, and even in terms of parenting. We talk about it. It doesn't mean that there isn't room for interest-based negotiation. There is, but they need to know what is their bargaining power. And what I mean by that bargaining power is are they sitting in the mediation room like this, like, bring it? Or are they like, because, right, because people need to know where they stand. It does affect posture, and it should affect posture.
Completely agree.
We don't want people to reach deals based on their interests and needs only, sign their agreement, and then months or years later find out that they could have paid this, or they could have received this in the legal model. We want them to make an informed decision. So that is the answer to your question.
So how do you, balance, this is a concept, self-determination, where the individual has ownership of making their decisions. So you encourage, you support people to get independent legal advice.
Yes.
And they, in a conscious level, say no.
Yeah, and I can't drag them by the ear and say, you're going to go into this lawyer's office. When clients first contact me and I talk to them about the process, as a given, I'll just say, and you know what, after I've drafted up this agreement, I would like for you to get ILA on that. And most clients will hear me and they'll go, okay. And they'll do that. I mean, I think other mediators, I've heard that other mediators have more difficulty with getting their clients into getting ILA. I tend not to have difficulty. I tend to tell them the reasons why. And there's two main reasons why. Number one, they're getting valuable information about their agreement and what, how their agreements are how their agreement is going to stack up against the legal model. And number two, that if they don't get legal advice, it is possible for one or both of them to try and set aside that agreement in the future to say that they didn't know what they were signing. So that is, and when I say that, then people go, okay, you know what? I think I'll just go and do it.
I hear you, and I understand, and I appreciate. It
But?
depends to, yes. Well, I'm not going to put but because I don't believe in the but. I'll do the and word. I substitute but
and yes.
for but. I put that in there because it's not to minimize the first thought and statement I just made. It's to build upon it. So, and, all my years in doing community mediation, talking about memorandum of understandings, not once was there ever the thought or the threat that anything that was created as part of that was going to ever be challenged. Some of this idea of this energy that, hey, it's a legal thing and it lives within a domain of a legalistic society, the shadow of the law, that a lot of that energy comes from the system and the judicial individuals, stakeholders who are part of that. And I think you would know from your community mediation days that there is the idea that provides people with the power to make their own decisions. And people have been functioning for eons of years, being able to do so. Yeah. And it's the construct that the system says you must come to us that it legitimizes your decision-making, I have challenges with.
Well, I'm not saying in any way that, because your original question was around self-determination. Can people still have their right to self-determination and still be encouraged to get legal advice?
Yes. Yeah,
yes,
for sure.
So that's all I'm saying. I mean, maybe I didn't quite answer that question completely, but I in no way, I mean, I believe so strongly in clients making the choices that they want to make in their deal in the mediation room. And if one person wants to give up $300,000 that's sitting on the table, great. That only happened 2 weeks ago in my office, right? So it's okay for people to do that. It's all about being informed. And I am not putting the hammer down on anybody in terms of their ability to, have self-determination.
Yeah, I totally understand that, and I appreciate that. It's to present that whatever I say, there's more to the story. Whatever you say or Laura says, there's more to the story. We're not the end-all be-alls here. We're presenting information. And, the idea is, this is one of the purposes of the program is to serve as public education, to give people access to information. So not even when they're present in the moment to watch this, that they can have access to it afterwards.
Yes, that's right. So all I'm doing in the mediation room is giving information and facilitating discussion. And if people say, thanks, but we're not interested, we're deciding to leave this process in mediation, fine, no problem, right? It's a voluntary process. I can't make you be here. And I also can't, and I'm also not interested in having you adhere to the strict legal model, just simply to know it. Mm-hmm. And if you know it, great, you can make whatever deal you want.
I completely agree with that. This is why the model that we work with is I took it from the community model, which is where is the co-mediation model. So I work exclusively in a co-mediation model. My background is mental health, and my co-mediator, he or she, at that whichever comes with that mediation, are family lawyers. So we are focusing heavily on providing the information, on making sure that the process and all of the information is delivered neutrally, and also is they're making a decision transparently. So we look at the transparency of everything. So if they're going to leave 300,000, if they're not going to add whatever car into the the financial property division, all that stuff, that's okay, as long as they know that that can be added in. So when
you mean in the strict legal model, you mean? Yes.
Yes, we always show it. We start with that. We always show that. So I'm aligned with you 150% on that, because without that, there is a risk that later down the road, you know, not only a lawyer may inform them of, you know, different things that could have or would have, but also, you know, their neighbor, their family friend, their new spouse, whomever, you know. So at that point, I want them to have the ability to say, I know, but I have chosen this way. So and that's the power of the agreement. That's how I feel that the agreement will stand the test of time. Sometimes the information is completely uncomfortable. Sometimes families do not want to share certain information. And we have to work with that to bring that information on the table, at the table, and create a space where that uncomfortableness becomes something that is not going to impede on a fair process, transparent process, and coming to an agreement that is going to stand the test of time. Is very important to us. That's why we create the way that we create anyway. And in terms of the ILA, we believe in ILA. We believe in all the ILAs ever. But then we go back to a little bit of who's giving the ILA, who's providing the ILA, and how is the ILA, the independent legal advice, delivered to that client. That is very critical, because there's fear-based ILA, and they'll tell them, I'm not signing this, and we've seen them all, we've seen those. And that's the fear that it actually pushes away those families who really just want ILA, but now they're fearful because they've heard all these horror stories and agreements being ripped up, and say, no, I'm not signing this with you. You shouldn't be signing this. It's, you know, a horrible agreement, this and this and that. So I don't find the balance there, right? So it's hard for them to find. If I don't find the balance, it's hard for the families who are going through this experience to find that balance, right? So it's tough. ILA, I think everybody should have ILA, but who's going to give it?
Yes, and so you develop a roster of mediators, of ILA lawyers who you can work with, right? As a mediator, and I have that roster, and other mediators refer to me. And it is rare, I must say, that any of the ILA lawyers that I refer to say, you know, this agreement is a piece of garbage, right? Mm-hmm. That it's just, I think that if lawyers are looking at your agreement as a mediator and saying this is, you know, that this is no good, then at some point the mediator missed something, right? That's just my perspective on that. It shouldn't happen that way. I think we as mediators should be anticipating what lawyers are going to say and what their reactions are going to be. And we've coached our clients a little bit on that too, and said, look, your lawyer's going to say this. Mm-hmm. I just want you to know about that, right? Sometimes we as mediators may call the ILA lawyers and say, look, this is the agreement that's coming down the pipeline here. This is what it's looking like. That might be a way.
So taking off what Laura and you, Neeraj, are presenting, I believe a powerful negotiator is an informed individual.
Yes.
So having access to all the possibilities, it's how they make the decisions with that. So how do you see the people having access to their rights contributes to their capacity to negotiate?
How, say that last sentence again?
How do you see people having access to their rights, so that independent legal advice,
Yeah.
how does that contribute to their capacity, their ability to negotiate?
Oh, well, that's what we talked about. That's what I mentioned about bargaining power, right? People need to know what their rights and responsibilities are, because it does affect posture in the negotiation room, right? And I mean, just you know, on a basic level, a person can have a belief that, well, I received legal advice that I'm entitled to this in terms of property division. And if the other person is sitting there saying, well, I think you should only get this, then you know that, you know, because it's in your back pocket, that the legal model can provide you with another outcome. So it affects posture. And it's necessary. Bargaining power is necessary. It's a necessary part of informed negotiation.
And I'll just put it out there for anybody in the crowd in the bleacher seats. If you want to make a comment or ask a question, we welcome you to do so, because we're nearing the end of tonight's show, and I'm sure you're just sitting with something.
Oh, all right.
I don't know. It's an opportunity.
Can I just give a shout out to my students? I teach the family law course through the continuing education department at York University, and I just wanted to give a shout out to my current students.
Did you want to do a shout out to anybody else?
Just give a shout out to my parents. Give it a little shout out to my niece and nephew.
Just a couple more things.
Yes.
How do you process your own challenges with some of the decisions people make, or some of the lived experiences that people are going through? How do you sort through that?
Don't really take it personally. The decisions that people make in the mediation room, they all make sense to me. They all, you know, I get it, you know, and I've not come across one client in 16 years who, you know what, who I thought, you know what, I don't understand why this person is doing what they're doing. On some level, like I may not fully empathize with it, but I understand. And so I don't take it personally when, you know, the decisions that clients make in the mediation room. And that's not my job.
How did you process what you mentioned a little earlier, that one of your clients left $300,000 of value on the table? How did I said, okay, yeah, how did you process that?
Simply by saying that to myself that I did my job by running the calculation and putting it right up to their face and saying, look, this is the amount that's being left on the table. And the client said, I'm good with that. It makes sense to me, and here's why. And then I wrote down, here's the reasons why. And that even made it into the agreement. Here are the reasons why. And I totally respect that client for the decision that they made.
Yeah, and I think that's one of the skill sets of a mediator, is to say, we can be connected with people to create, you know, empathic relationships that are about recognizing the humanity of individuals and their decision making. At the same time, we know our role, our boundaries, if you want to call it. We don't take ownership for the people, the other people, the parties' decisions that they make.
This was the beauty for me of doing mediation as opposed to lawyering. And, you know, I still do a little lawyering, but just in the ILA context. But this, when you're a mediator, you're not taking the burden of the client on your shoulders, right? It's that you are there to help them create a deal. But as a family lawyer, I felt such enormous pressure to make them happy, to make my clients happy, and you know, you to get the deal, the best deal. And I think that is the beauty of being the mediator instead for me. It's a much better fit for me.
Well, people will appreciate, I'm sure, through your approach, your manner, your process, and how you construct that you're a person who obviously wants to help and support them the best way to get what's best for them. So it's more about them, it's not about you. You create the conditions for them to connect with, to make those decisions.
That's all I do. That's all I do. I'm a facilitator.
What do you want people to appreciate from our conversation tonight?
Oh, geez. I think I want people to appreciate that mediation is a really, really good process for the right kind of families who want some legal education about, you know, the rights and responsibilities, and who want to still be in charge of the decisions. I think that's probably what I would say. It's a very, very nice alternative for clients who can do it well.
I think they can do it. I'm
Yes.
the optimistic mediator that, you know, structure the proper way mediation works.
Every time you
You know
are?
what? Mediation works, even if it fails, they have gotten
Yes.
about 80% closer to an outcome, because at that point they have information, they have financials pretty much, you know, done. They have, you know, they have a few more steps. They know where they're at in terms of what they want from each other. So they're already steps ahead. And I'm really, now I like your idea of having a roster with ILA. I usually I just tell them go get, you know, legal advice. And unfortunately sometimes, and I've had, like you've had the 300,000, we had last week we had a lawyer coming advising the client to go back or to start litigation over 10,000, and I'm talking about a deal of 2.3 million.
Wow.
So that's when you pick up the call to the ILA lawyer, like you had suggested, and say, hey, do you really want to? You really want your client to fight over this $10,000? Well, you know, it's not this and that, it's contingent tax and all that stuff. I said, please answer the question, yes or no question. Do you really want to? Because we can re-engage in mediation. By that time, they've already spent, you know, a chunk of money to come to a very solid agreement. And then you have one ILA lawyer who really was ready to, I'm not sure what the agenda was, if it's billable hours, if it's whatever it was, who was really, you know, pushing the client to go get more. Or go get this particular. So these are the unfortunate stories that will go out to other families, right? They closed the mediation, so in the end they did not. They remained with the deal. They signed the agreement actually yesterday, so that's fine. Actually, no, on a Good Friday they signed it. On Good Friday they signed it, so good for them. But I'm relaying to you a very critical story that unfortunately we get, because it's not necessarily the agreement. It's not how they got to the agreement. It's not, you know, whatever is written in the agreement. It is actually the person, the lawyer who is delivering that ILA. How do they deliver that ILA, and whose interests are they serving at that point, right?
And
that's important.
And we have a real stake in helping clients to choose that ILA lawyer. So make sure you get that roster. Very, very important. I always, clients always ask me, okay, give me some names of ILA lawyers. I have my roster. I'm ready to go.
All right, I'm exchanging a roster.
Well, in addition to that, it's also to have other resources available to provide your clients in case they need of something else, i.e. counseling as well.
Of course.
So it's, you know, what can we do to help support the individual in relation to another individual to best be connected to themselves to make the most powerful decisions they can. So people sometimes need access to other possibilities, resources, professionals.
Yes, that's part of my roster too. Family professionals, financial professionals, valuators, ILA lawyers, all those people.
Beautiful.
So what's next for you as we soon close out?
Yeah,
tonight?
Uh, I think I mean at this point more of the same. I'm happy doing what I'm doing. Sometimes it can be a little bit overwhelming, and some being in business for yourself, there are its peaks and its valleys, and I just came off of a peak. So I'm looking forward to things being a little bit slower for me, but I continue to hone my skills and do what I'm doing.
Well,
I just want to make a comment before we close out. So thank you, folks. Sorry, I have to sign off now. Very interesting discussion, and really like that it is understood and appreciated that mediator and lawyer and other resource professionals can and do work together.
Yes, thank you.
I think that's a great message, because we do need to work together. That's the bottom line in the end.
Yes.
Rather than pointing to the distinctions, I think it is important when we actually come together, then the family wins. When we all come together with proper ILA, proper process, mediation, informed decision, all of that stuff, then the family wins ultimately, which is that's the goal. That's the goal.
And more mediators need to understand how they can make it easier for the ILA lawyer to do their job. And I sort of give a bit of a sermon about this in the course that I teach. And so that's for another day. But just to say that, mediators and lawyers absolutely have to work together. And there is a duty, an obligation, I feel, that family mediators have to make that transition for the client a little bit smoother to ILA lawyers. And ILA lawyers, of course, have to be not interested in ripping up agreements, of course.
Right.
Yeah.
Thank you for that.
Thank you.
It was
Okay.
really nice to meet you, and
Nice
I'm
to meet
really
you too.
hoping that our paths will cross. And if you can share was it an article that you wrote about it, or?
I have articles I've written about it. Absolutely, yes,
Okay.
yes, I can
So
share
if
some
you
articles.
can
Yeah,
share that would be cool, because I would love to read some of them.
for sure, absolutely.
All right.
So thank you, Neeraj, for availing us of your presence and your contributions and your input, and appreciate it. And I'm hopeful that it was, something that met your needs and your interests too.
Yeah, absolutely. Thank you. It's an honor to be here.
Thank you, everyone, and thank you, Greg. The program is now going to turn off. So thanks everyone for being here. You will see a screen now that's going to kick you off, essentially. So.
Yeah, the recording will stop, and then we'll say, "See you next week."
There we are. Yes. All right. Have a really good night.
Have a good night to everyone. Thank you for visiting.
Thank you.